Hello, IP friends. Welcome to my podcast called #IP Series with Reader. So, if this is your first time joining us, thank you so much for listening to my podcast. Please don't forget to favorite after listening on or before you listen. And don't forget to also share with your friends. And for my returning listeners, you guys are the best. Thank you so much for always coming back to listen to my podcast. And please don't forget to tell your friends about my podcast. What we do here is talk on intellectual property. I talk on recent cases and development. It could be a copyright case, trademark, patent, industrial design, trade secret, plant variety, or geographical indication. Anything related to intellectual property. And as we know, IP is everywhere. So, yeah, come join me on this ride. So, today's episode features the case between Kiki Mordu and OgeObi. Issues I'll be dealing or talking about acknowledgement, credit, and intellectual property theft. So, I think one thing people need to understand when it comes to IP is you need to understand or get the basics of intellectual property, which protects creative and innovative works. And in my introduction, I listed the forms of IP: copyright, trademark, patent, industrial design, trade secrets. And one thing you should know that IP doesn't protect an idea. So if you say, "Well, I had this idea before this person," but you did nothing about it, you didn't convert it into something we could see. You didn't create anything. You did not make anything. You didn't manufacture anything. But you keep saying, "This person stole my idea. This person stole my idea." Look, man. IP doesn't protect ideas. So sometimes I have those questions from clients like, also I have this idea I want to trademark. I'm like, okay, what exactly do you want to trademark? And they're like, oh, there's this idea I have. And I'm like, no. Yes, hold up, let's go back. And then we have those conversations where you need to understand the basics that if we don't see something, say a book or an artwork or sound recording or a phone or a chair, anything, say a logo, whatever, if we don't see any of that, it can never, ever be protected. So that's like the long and short of the basics of intellectual property. So even if you go, so you go and pitch to a third party without any work or product to show, you cannot come and claim the right to that work because you've not shown that you've put in sufficient effort or you've improved on anything that was already existing. And that's what happens sometimes. People go and like, oh, I pitched my idea to this person. So the idea you pitched, was it a product? Did you show any product? Was it a book? What did you go and pitch? Oh, I have this idea about XYZ, blah, blah, blah. And they told me they loved it. And then let's say a few months down the line, the company now puts life into the idea you said you had pitched to them. It's, what do I say? So a lot of people will say it's best to like sign an NDA. Signing an NDA with no actual product is going to be like useless. You get. So understand that if you're going to claim right into anything, any intangible asset, we need to see that asset you're actually talking about. I hope this makes perfect sense. Now let's get into the main deets for today. Now, in Kiki Mordu's case and OgeObi, we'll be focusing on a form of IP called copyright, which protects original works in a fixed medium, say a book, architectural work, art, sculpture, sound recording, music, cinematography. Like those are like the eligible works that can enjoy protection under copyright. So under section 10 sub 1 of the Nigerian Copyright Act, it provides that the moment the work is created, it enjoys automatic protection and also gives exclusive right to the person who created the work. So the person who creates the work is known as the author. That's the first person who created the work is known as the author. However, under subsection 2, it says provides an exception where the person who created the work cannot claim copyright to the work in question. 1, when it was done under a contract of service, for instance, they work for hire, hired to do something. Without a contract, you are the author. But with a contract, you are not the author, because the clause the IP clause states that once the work is done, you have to transfer all rights to it. So which is why when you are giving those kind of work, you need to negotiate what you feel you should own and what you shouldn't own, and talk to your lawyer, specifically your IP lawyer. So we don't come and see Twitter threads, but Twitter I do enjoy the Twitter thread. So yeah, secondly, while you're in employment, so it's said that if you're an employee and you create something, the work belongs to your boss and not you. So where that happens, so your contract states that, your boss owns the work. You can't come as tomorrow to say, I worked on that XYZ, I created this, I created that. What did your contract state? So that's it. So in this area where there's a lot of social media call out, it makes it impossible for parties to always refer to contracts or speak to their lawyer or find a way to resolve this dispute. There's very few cases where if the parties are reasonable, they sit down and want to renegotiate or talk about percentage and payments, what's due to every other person. Then another thing we need to consider is that authorship in copyright is said to be the person that created work, which I already explained. While ownership means the person that merely contributed information, suggestions, but does not know how the work was expressed at the end of it. So for instance, now in your office, you're tasked to do something, so you send out concept notes, and then the person that executes the concept note becomes the author of the work, while you're the owner of the work. So but then again, a contract is what specifies everything at the end of the day. So always know the difference between who an author is when it comes to IP and who the owner of an IP work is. Authorship and ownership are two different things. It is only the owner of the work that gets to enjoy the exclusive rights. The author of the work that gets to enjoy exclusive rights to commercialize and exploit the work. These exclusive rights include the right to sell, the right to use the work, the right to copy, the right to make derivative works from it, the right to also licensing. Now, I've always talked about or made emphasis on CPA. CPA means consent, permission, and authorization. It's very, very important when it comes to IP. I have already talked about work for hire in my previous episode when I was talking on the case of the Living in Bondage film and the lady who made some designs for the film. She had come out on Twitter to call out the company or the makers of the movie, saying they had used her design without her consent and no compensation. Luckily, she was compensated at the end of the day. So in order to sort out those kind of issues that may come up when it comes to authorship or ownership of a copyrighted work, make sure you sign a contract and read that contract before you actually sign it, guys. Other than having the exclusive right to sell or license your work, you also have the economic right to earn money from the work you've created by exploiting and commercializing the work. You also have moral rights, which gives you, the author, the right to determine how the copyrighted work you created will be used, especially when you have sold or transferred the rights. So they can't defame how the work was originally created. I hope that makes sense. You can also, sometimes another thing is that that people do without actually knowing is that a clause that provides that you should let go of your moral right will be included there, but because you did not read your contract, you did not even give your lawyer to read it for you, you end up not even having to exercise your moral rights or paternity right, as we call it. So when you have about several authors who has contributed to your work, you're all known to be joint authors of the work. Who owns a copyright in an anonymous work? Now, I did put up a poll, and 32% said the publisher, 27% said they did not know, 22% said the employer, 19% said the ghost creator or the writer. Now, an anonymous work where you've signed, so it's more like a work for hire. So basically, you can't be the author; it's the publisher or the person's name on the work that would be known to be the owner of the work. And then if you still want to retain rights, you also have to sign a contract that say, oh, even if I have sold, I still retain certain rights to earn residual royalties. But that's why you need to talk to your lawyer, your IP lawyer. I keep stressing your IP lawyer or your copyright lawyer, so that you are properly guided and advised on the right thing to do. So if there's a joint work, it's advisable that you sign an agreement. If there's no agreement, then you guys can, what we apply is that all of you are parties are all joint works. It's a collective work, and it is a derivative work. That means it can be translated into a motion picture. It can be dramatized, making it exclusive to the person that has translated the work. You also need to obtain CPA. Very important, guys, if it's an original work. So with this Oge and Kiki Mordu's case, I had put up another post stating, do you think OgeObi owns the work? And 59% said yes, and I was like, really, guys? After all these explanations I've been doing. And then 17% were like, yeah. And then 14% were like, then 10% were like, money. I mean, yeah, who wouldn't pick money? But I was like, okay, I think I need to still explain some more. And I went further to explain the following. So before you go around and say, he stole my work, that was my idea. I said it first, or I did that first. I created that first. Make sure that you have understood the basic things when it comes to IP. Whether it's IP theft or IP infringement, and basically this is when someone does the things that are exclusive to an IP owner, such as selling, licensing, exploiting the commercial aspects or economic aspects of the copyrighted work. If the person uses a substantial part of your copyright work without your consent, permission, or authorization, they are guilty of IP theft and infringement. And you should talk to your IP lawyer. Lawyer up, guys. So I did another point. I said, does OgeObi idea have commercial value? 63% said yes, 37% said no. Do you still think, from my brief explanation, that Kiki Mordu is guilty of intellectual property theft? 69% said no, 31% said yes. And like I stated, IP theft or infringement is when you do things that are reserved for the author of the work. That is, you sell, you license, you exploit the work commercially and economically, or you use a substantial part of that work. So what is important when it comes to IP theft or infringement is, was the work in question vital to the material that was tampered with? That's something that you and your lawyer need to sit down and analyze and talk about. How do you avoid being accused of IP theft or infringement? 1, do your due diligence to determine who the owner of the work is. 2, documentation goes a long way to determine who the real owner and author of the work is. 3, always obtain a CPA license or assignment. Get your IP clearance. Should get me. Okay, so in conclusion, it is clear that a lot of Nigerians still don't understand the basics of intellectual property, and IP basically interfaces with every sector. So it's important that you know these things of when it comes to authorship, ownership, what is eligible for protection, what IP theft is, in importance of CPA, that's consent, permission, and authorization. Another thing is that as a creator or an innovator or an IP owner, you can opt or explore a multi-layered IP protection. So you're not just opting for copyright protection. You're thinking of design rights, you're thinking of trademark, you're thinking of patent rights. It depends on what your content really is or what the work in question is all about. That way you are protected on all angles. And very important, IP does not protect ideas. Ideas are not eligible for IP protection. They don't enjoy any form of protection as an intellectual property. IP is an intangible asset which every business or person should own. My podcast is an IP. Just giving an example. See, if you are within the creative space, always talk to your IP lawyer. Have an IP lawyer on your retainer. Even if you're not on a yearly retainer, at least a monthly retainer or a per brief retainer would do a lot for you. Always talk to your IP lawyer instead of opting for social media callouts, Twitter thread, Facebook posts, Instagram lives, all those things. There's a flip side to this, because you might do it in a way that it backfires and it now becomes it's rather seen like you being a cyber bully, or the person being put in the spotlight to be stalked or cyber bullied from keypad warriors or anonymous people. You end up being accused of defaming the person's character. You now also infringe on the person's right to privacy. So those are the issues. These are the issues, guys. Another thing that I like to advise people on is that when a dispute arises and you talk to your lawyer, so there I'll say there are 3 options, or let's stick with 2. First is you can opt to settle out of court by exploring negotiation, which is a form of alternative dispute resolution mechanism. You can also opt to mediate or arbitrate, or opt for a hybrid form of resolving the dispute, where you start with mediation, and where you guys don't come to a conclusion, you now go into arbitration. Then you have the option of filing a suit. So filing a suit in court. So I did mention that we have 3 ways. So 1, you can talk to your lawyer and they do a cease and desist letter to the person, giving an IP notice, telling them to stop using your work without your consent or whatever the case may be, and then try to negotiate, which is exploring out of court settlements. Then you can, if you're not up to go to court, that's litigate. The court that has the jurisdiction to hear all intellectual property cases is the Federal High Court. Now, on right to claim authorship in Nigeria, read section 12. It expresses and talks on how you can claim authorship. It also focuses on how the heirs and successors of the deceased IP owner can also claim authorship in the work. There's a podcast coming out on that. I hope you guys are excited as much as I am. Okay, moving on. Then you have on infringement, read section 15 of the Copyright Act. Also know that copyright in a work could be a cinematograph, film, broadcast, literary, artistic, or musical work. Read section 51, which is the Interpretation Act or section. Then, before you sign that contract, give your lawyer to help simplify things for you, and also look out for your best interest. That's what we are here to do for you guys, because intellectual property is territorial in nature. It's only the jurisdiction or territory or countries that you register your work, and in this case in Nigeria, that you only get to enjoy protection within Nigeria. Now, in closing, after reading snippets from the Kiki Mordu case, her own version, OgeObi's version, and comments and everything, this is my own opinion. I don't think Kiki Mordu is liable of any IP theft. She did not use anybody's work with her consent. That's substantial. She did not sell it or license it or do anything that is exclusive to an IP owner. Whatever the contract she had signed with BBC gave her room to be recognized as the author, but not the owner of the work. And like I earlier said, that there's a clear difference between authorship and ownership. You may have brought the idea, but you can't claim ownership because it wasn't expressed and in copyright in a fixed medium. You get authorship with regards to an employee. The scope of your employment letter will determine a lot. For instance, a journalist who writes features, your employer gets the right to publish the write-up. But if your contract states otherwise, that even if the company publishes the work, you're still the author and owner of the work, that gives you more leverage. Do you get? I do hope that I've been able to answer all the issues that arose from this case. I found it really interesting because it created a lot of buzz online, and I had a fab time I had a fantastic time when I was reading and writing about it and also researching about it. So I do hope you guys enjoyed listening. I hope you learned something. If you did, favorite my podcast and follow my podcast. Also, please subscribe to my newsletter. Until the next episode, thank you for listening again and have a fantastic day, guys. Cheers.